Welcome to Dolly Talk. This is Dolly. How is everybody doing? Right. We were going to be doing Judge Simpson, but it was a short one today. And there wasn't a lot there. And there wasn't a lot there. So I figured I'd do some more of Middleton. Paul, first, how are you doing? Brad, Leighton, Leighton Meg. I was not late. All right. Let's see here. I thought I was in the right one. There we go. Okay. Sorry, guys.
Any lease here? Is there a lease?
There is not, Your Honor.
Oh, let me go back a little bit. Oh, we got Meg.
I went to the treatment court conference for a couple of days, and I think somebody turned the heat down in this courtroom. It's about 60 degrees in here. That's what you get for leaving. Mr. Oliver. Oh, there he is. Thank you, Elaine. Good morning, sir.
Good morning.
Are you Edward Oliver?
Yes, I am.
All right, this is Judge Middleton. I'm here at the courtroom. I'm not afraid to have you here in the courtroom, but you're in the conference room in case we have a need for a consultation for you to speak with an attorney. But this is pretty straightforward. This is file number 25133 LT. It's entitled Robert Jacobson versus Edward Oliver. This is a property on Garber Road here in St. Joseph County. Also with us is attorney Megan Bauer from Legal Aid of Western Michigan. This is a termination of tenancy. Apparently your landlord wants you to move, and I didn't find a lease, and served a notice to quit on you in December. At this point, they're not asking for money damages. They're simply asking you to move. And when you are a defendant in this type of case, you have legal rights, and I will tell you about that here. You have the right to hire an attorney. If you can't pay for one, the court will give you information about legal aid or other options to try to get legal services, but frankly, it is difficult. But as I indicated, our legal aid attorney is here on the floor. How long have you been at this property?
For at least 6-7 years. I was taking care of.
I'm sorry, go ahead.
I was taking care of their father, which was handicapped, couldn't use his legs.
And then he passed away?
Yes. And I pulled my back out helping him and went through back surgery.
When did he pass away?
Let me see, it was I believe it was, I'm not sure the exact date, but it was before I went to jail.
What year was it?
I've been in jail for 7 months.
Jeez.
Where at?
St. Joseph County.
So you got out of jail and then you went back to this Garber Road property?
Yes, my stuff's still there. I didn't expect to go to jail because I was under medical treatment still for my back. But they
Most people don't.
That must have been Judge Stutzman. Well, at this point, it doesn't sound like you're paying any rent. Your stuff is there and you don't have a lease. So have you got any plan to relocate?
yes. Well, I'm trying. I just now got a phone back on, and my bank dismissed me the other day. All kind of good news, and I don't have any transportation because my insurance expired while I was in there.
Who put you in jail, Judge Stutzman?
Yes,
Some would say he put himself in jail.
Let me take a look at that. Well, it was a felony charge of some kind. All right, so you have no money, no transportation, no good plan. Nobody really wants you to be out on the street, but they do have a right to get their property back.
yeah.
Mr. George, what do you know about this while he was in jail? Did they take any action at that time?
They did not. Just so the court is aware, our client is one of the sons, and he's not local. And I don't think that there's really any family that's local left. So I think they're trying to get Mr. Oliver out and, you know, make other arrangements with the property, and that's why they took this action.
Yeah, this was odd because your felony charge was from 2022. And so you went to jail, I think, in 2023. Is that true?
Yes, sir. I was under medical condition. I had 3
All right,
operations.
so have you ever paid any rent?
No, it was an agreement that we had when I took care of his father.
All right, well, this is, I see why this is coming this way. You're living there rent-free. Are you paying the utilities?
Yes, I was, and also maintaining the property. It is 40 acres.
Drake is 40
It's a
acres and a
farm.
mule.
And they lease the property out to a farmer.
All right. Well, the law says that I must adjourn this at least 7 days. So let's take a look at what next Friday looks like.
And Judge, before we get there, I'm not going to be available next Friday. So would the 10th be available, which would be the
Sure,
following
let's take
Monday?
a look. Darn it, my thing's locked up here.
Damn it, Judge.
Yeah, March 10th. Yes, I'll be here. That gives you a little extra time. 2:10, does that work?
Yes, sir.
March 10th, 2025 at 2:10. You're welcome to come in just like this, sir. Or you can Zoom in, and maybe we'll even have you in the courtroom at that point. But at this time, you're in a tenuous position. You don't have a lease. You're not paying any rent. You've been there for more than a year and a half. He died. They want to do something with the property. In order to do that, they're gonna have to get you out of there. So if they get what they ask for, you would have until March 17th to move out.
Yeah, well, we can't always get what we want now, can we?
Do you get disability or anything? Do you have any source of income?
I was on Social Security, but I'm not sure anymore. I haven't contacted anybody because I didn't have access to the internet and telephone, but I do now.
When were you released from jail? I thought that was way back in 2023.
No, I just got this month.
Oh, you just got out just now?
Yes, I was under surgery for my back all the time till October of last year.
Well, this didn't become a sobriety court case. It became just a jail case by Judge Stutzman. Well, anyway, let me repeat. We're going to continue this until March 10th at 2:10. If they get what they ask for, you would have to move 10 days after that, which would be March 20th. So it gives you 20 days to figure out what your plan is. And that's the eviction is where the sheriff comes and forcibly puts your stuff out in the street. Nobody likes that. Do you have any questions?
No, I was just going to go to the Veterans Assistance Program to get.
All right, so you are a veteran?
Yes, I am.
All right, I would suggest you do that right now while you're here. We've had pretty good success with our veterans advocate, Stoney Summey. He works for the county. He's got a new assistant, Lindsay, and they're pretty good at trying to help veterans find some housing. So I would suggest you go see Mr. Summey right now. You know where he is here at the courthouse?
No, I don't.
All right, ask the bailiffs. They'll tell you where to go. He's right here in the old building across the hall.
Okay.
So ask the bailiffs and they'll show you where to go. Okay?
Sure. Thank you, sir.
All right, Meg, I'm not sure there's any reason to connect. It just is what it is. All right, you go out, talk to the bailiffs,
Suffer
go
me.
talk to Mr. Summey. I've seen him pull a rabbit out of a hat more than once and find a housing for somebody, and maybe he can help you. Okay?
Yes.
All right, thank you, Mr. George.
Thank you, Your Honor. Have a good weekend.
Okay.
Thanks. From again, the end of his tunnel. Good morning, everyone else. We got started right on time. We're 1 minute behind. Barry Weiss is here. Excuse me, Brian Weiss. Barry Weiss is a character in a non-reality show. Brian Weiss is here. He's a character in a reality show also, but his reality is reality. Mr. Minsky is not here, and I'm not surprised that he's not. This is Ben's Investments, care of Berkshire Hathaway versus Michael Minsky. This is a property at 435 Prospect Street. Mr. Minsky has failed to appear for several court appearances. I believe he may have an open warrant, although I wasn't clear on that. He was served by attachment. Let me just make sure he's not here. Hi, I'm checking to see if Michael Minsky is here anywhere. Yes. All right, thanks. Bye. He's not here. Let me look for a minute. Make sure
Oh,
he's
come on,
not in
Judge.
jail. Which I appreciate.
Gordon, Your Honor.
All right, let me give you a name.
I'm sorry.
You're fine.
Case is at 10:30, right, Judge?
I think so, yeah.
Oh,
Miss Gordon, let's take a look. Yeah, Andy Brock Properties. 709 square feet. I'd show it as set for,
It's a random fact, Brad.
can't read my own writing.
Is that on our LinkedIn?
221, it was set for 9. Here it's set for 10:30. So last time it was 9, this
Oh,
morning
nice.
it's 10:30. This is the second hearing. So in about an hour.
okay. Yes, Your Honor. I will.
All right, thank you.
Thank you.
All right. All right, we have a number of cases from Riverside and others by the Cox Law Firm. I think they've just arrived.
Judge, while we've got a brief second of downtime, just wanted to give you a heads up. I'll be here on Monday, but then I will be gone for the two, the 2 Fridays and the Monday in between. So,
Oh, good for you.
just, let you know.
All right, thank you. It's always very helpful when you're here. But I hope you have some good time off. Let's take a look at the calendar for a minute. So,
Whoa. What the fuck is that?
so you'll be here on this Friday, the 7th?
No, I'll be here on Monday.
Sweet Jesus. All right, guys, we got to zoom in here, figure out what the hell's going on. Okay. Zoom on over. Wow. That is a look. Okay. I'm trying not to be mean.
Monday, the 10th?
The 3rd. I'll be here on Monday, the 3rd.
Oh, Monday, the 3rd. Okay. And then we won't see you again until
Ah.
Monday, the
I
17th.
think I saw her in the newest
As
Star
long as I
Trek.
don't get held up at DTW. Yep, my plan is to work on the
Yes.
17th.
Is it an international flight?
No, just some family stuff down in Florida.
Good for you. All right, thanks. When I retire, I'm gonna take the month of March off.
When you retire,
Good morning. Attorney Raina Haddad has joined us. Are you with the Cox firm?
I am Judge Rania Haddad for the Cox firm.
All right, I haven't met you yet. I don't think. If I have, I apologize.
Nope, not a problem.
Your manager, Ms. Kalmbach, is here. We don't have any defendants yet.
Yes.
Our next case is at 9:20. So we'll wait to let the clock tick for a minute.
We will be waiting patiently, Judge. Thank you.
I always joke that the people fight about who has to go to Centerville, and the person that gets the short straw gets assigned to 3B District Court. So you must have got the short straw today. 8, 8, 4, 8, 8, 9, 7, 2. I do appreciate it when the attorneys put their P number on their login. All right, we have several Riverside cases. Ms. Kalmbach is the manager there, and she's managed some other places, but she's at that.
He was trying to make it some kind of joke about not working. I don't know. It fell flat. It sounded a lot better in his head, I'm sure.
Unit now. We have a number of non-payment of rent cases, and the first defendant is Sharitha Longs. Sharithia, try the bailiff again.
So, Your Honor, I believe that might be a dismissal if my client can confirm, because I only have one that's up today. I believe the rest might be dismissals, but my client can confirm.
All right, never mind, Jeremy. I thought I was looking for Sharithia Longs, but I think her case is being dismissed. So I'll get back to you if I need some more people. All right, thank you.
So Judge, just to make things a little easier, I believe the only case that is up today is case ending in 196. And my client can confirm that, and the rest that are up may be dismissals. I just want to make sure.
All right, well, let's call the first case. Riverside Townhouses versus Sharithia Longs. File number is 2519291. My memory was there was a previous case in this matter, and there was back in 2024.
You guys there? Shit.
Did she pay or move?
She paid, Your Honor.
All right, very
guys
good.
there?
Those are the best kind.
Agreed.
That's what. All right, I'll await the dismissal. It's probably en route.
I believe it's already been submitted.
Hasn't made it to me yet, but that doesn't mean
Okay.
it hasn't been
Sorry, I thought I
submitted.
lost the
Maybe she'll
internet.
bring it in. All right, so let's take up our next case, which is Riverside Townhouses versus Shemaine Raymond. The file number here is 24192LT. This is also a non-payment of rent case. What's the status here?
I believe that is also a dismissal.
Is, she is also paid.
Okay. Well, maybe you didn't draw the short straw. Everything today is going to be a dismissal, and so it'll be just letting the clock tick. 2/28/25.
Hi, Sasha.
Say your first name again for me.
It's Rania, like Tanya, but with an R.
All right. Names are important, and I often mispronounce people's names. I'm terrible with some Asian surnames and the
Whoa.
Hispanic names, but I think names are important, and I'll try to remember it. But I apologize in advance for when I mispronounce it next time.
No need, Judge, no need. I appreciate that.
Those damn Asian names. I love Meg.
All right, well, let's keep plugging away. Our next case isn't for 7 minutes, but we'll call it anyway, and then we'll have some dead air here. The next
boy.
matter is Riverside Townhouses versus Keithia Longs. I believe they're sisters. The file number is 25193LT. Again, the rent is $427 per month. What's the status here?
That is a dismissal without prejudice as well.
And she is also paid, Your Honor. I think the tax return time has helped out a lot.
Yes, this is the time of year we get tax returns, and people get caught up on their rent, and it's for my whole judicial career of 22 years and 2 months.
4 days.
And when I was prosecutor, people would pay their fines and costs during tax refund season. All right, that's also dismissed without prejudice. Next is the 196 case, which is apparently at issue. As long as we got time, let's see what we've got while we wait for the defendant. This one isn't set until 9:35, which is 10 minutes from now. It is filed as a non-payment of rent case. Service was by attachment. And the rent, it looks like either it wasn't recertified or it's either market rent. It was listed at $868. What's the current arrearage?
Currently, Your Honor, there is a balance rent to retain of $898 and 22 cents. That's not inclusive of the attorney fees and costs of $185. So the total redemptive amount is $1,083.22.
And if we add 868, is that the rent amount?
Let
Yes,
me
Your
take it. So it looks
Alright.
like, it looks like the defendant is just having a hard time getting caught up on maybe 1 month's back rent, and that just keeps
Yes.
piling up.
With an additional late fee. And all
Correct.
right, so if we add it tomorrow, becomes March 898.22 plus 868. Whoops. Makes it 1,766.22 plus 185 would be 1,951.22. I don't, the service is in the electronic file. Ms. Kalmbach, do you believe she's still there?
Yes, she is, Your Honor.
Looks like we did do a second mailing on this one as well.
All right, well, let's wait for 7 minutes
Oh, God.
and see who comes. Minsky. Oh, Michael Minsky? Yeah. All right, well, you're quite late. We'll come back to you in a minute. Mr. Minsky, your matter was set for
And gay.
9:10. I'm not sure what time you came in, but we'll talk about it in a minute. Well, as long as you're here, let me advise you and Heather Hooley of your rights as tenants in a landlord-tenant proceeding. You have the right to hire an attorney. If you cannot pay for one, the court must give you information about how to get an attorney, and Meg Bauer from Legal Aid is here on the feed. You have a right to have the matter heard here in St. Joseph County where the property is located. You have a right to demand a jury trial. If you wish to have a jury trial, you must advise the court at this hearing and be willing to pay the $50 jury demand fee or file the fee in the form in writing within 5 days and pay the fee unless the judge waives it for inability to pay it. If your landlord has asked you to be evicted from residential property because you haven't paid the rent, you may be able to get assistance from the Michigan Department of Health and Human Services, local coordinated entry agency. In our county, that is community action agency, housing assessment and resource agency, HARA,
Hurrah.
that's Neighborhoods Inc. Or if you're a veteran, you may be able to get some assistance from the Veterans Program. We sent that information to you with the original packet. You may be able to reach an agreement with the landlord by going through dispute resolution, mediation. Both parties are interested, the court can help set that up. You may be able to reach an agreement with the landlord. That means the case would get dismissed. If that happens, we could file something called a conditional order of dismissal. Good morning, Ms. Hooley. We had some dead time before you came in. You're a little early, and I do appreciate that. They tell us that your rent through March through February is essentially 1 month plus a late fee, $898.22 plus 185 in costs for a total of $1,083.22. Now, the law requires that I adjourn this matter at least 7 days, which would take us to next Friday, which point we would add in March rent. So the rent would be $1,766.22 plus 185 through March. The total of rent and costs would be 1,951.22. Do you have a plan to try to get caught up on this?
I do. I had been laid off and so I've just been struggling. I do got a plan. I'm gonna try to give her 500 for the February's payment, 500, and I won't get a check next week, only a 1-day check next week.
All right, well, here's the
So-
deal. I'm gonna adjourn this for 7 days, which takes us to March 7th. Let's pick a time.
I have seen that
Friday,
before.
March 7th.
I don't think she swings for my team, unfortunately.
What's that? Willie. Oh. How about how about 2 o'clock, Friday, March 7th?
Okay, that's fine.
Now, you would get 10 additional days from that day to move out or be subject to being evicted. So that would take us out to March 17th, St. Patrick's Day. Even then, they don't have to evict you on March 17th. They can agree to work with you on a plan to get caught up on the rent. It's easier to keep a good tenant in there than to move one out and move another one in. So you've got a plan. Do you expect to get a tax refund?
I have a court order to pay hospital bill, and so they're
Oh,
gonna
so you have a
take my
tax garnish?
taxes. Yeah,
All right. Where do you work?
IAC in Mendon, Michigan,
All right.
International Automotive Components.
That's a good company and they pay pretty well, but I heard they were like laid off for a while. So, all
Mhm.
right, you got a plan. I'm guessing that you're a good tenant. They said you were just struggling to stay current. So let me repeat, we're going to adjourn this matter for 1 week to March 7th at 2 p.m. What shift are you on? I think she froze up. What shift are you on?
A second shift, 2 to 10.
2 to 10. Well, maybe we can do this a little earlier. How about if we do it at 1:10? And you do it before you go to work. Will that work for you?
Yeah, that'll be okay, yeah.
All right, now, the other thing I recommend is you go talk to Miss Kalmbach in the office about your plan to get caught up. And perhaps we could do a conditional order of dismissal or work something out for you to get current. But it sounds like you're gonna be able to salvage this. So let me repeat, if I add in March plus costs, you're gonna owe $1,951, just short of $2,000. And we will address this again next Friday at 1:10, okay?
Okay,
Do you have any questions?
no,
No? All right, you're good to go.
no. All right, thank you.
Okay, I'll remove you.
Okay.
All right, Mr. Minsky, stay with me here. I'm gonna bring somebody else in and see who this is.
Ms. Haddad,
What?
I was hoping I could ask Attorney Haddad a quick question on that case.
Okay. Go ahead.
Attorney Haddad, do you know if your client is open to a repayment arrangement or some kind of settlement?
Well, my client is in the Zoom gallery, so we can ask her. What you could do is, I mean, you can speak to the defendant and then you can always reach out to our offices. And if they're amenable to a reasonable arrangement, I mean, that's if they're willing to enter into any type of arrangement. But my client is in the Zoom gallery. We could ask her if they're open to that, or we could just have a discussion.
Well, I
outside of
saw her
court.
nodding her head. Ms. Kalmbach, you often will work out some sort of a arrangement with your tenants. Is that something that could possibly be worked out?
Unfortunately, the one thing that my boss won't let us do is do payment plans on rent because more rent keeps coming due. That's just something that they won't allow. me to-
Well, when she comes in to talk to you, you can explain that to her. But other thing you can do is just not ask to serve the writ. You have 56 days from the date of the order to ask for the writ of eviction, which is sort of like a pocket.
That's actually what I do, Your Honor.
Is just wait and give them extra time.
Yeah.
All right, well, you can explain that to her. IAC, as you know, is a legitimate employer and, but they had some layoffs or shut down, but I think they're back up and running.
Your Honor, is there an option for her to get some type of, assistance financially? I'm not sure if.
Well, I told her all that and it's in the packet that I sent to her. The
Okay.
problem is she's probably not eligible.
Well, if she's
if
working,
she's-
if she's working, she might be eligible. One of the caveats is that they have to be working because the state emergency relief, they need reassurances
Yes.
that whatever that they won't cover,
Yes.
the defendant will cover.
Well, and I don't believe this is subsidized. Is this market rent? Ms.
It is a
Kalmbach?
market rent, correct?
All right, so she may be eligible. I didn't stress it, but I did tell it to her and I gave it to her in writing. So maybe we'll discuss it next time. And Lori, if she comes in, you can express that to her.
Yeah, I definitely will.
All right, now I've got Michael
Thank you, Judge.
Minsky on standby and I've got somebody that came in on a telephone only, 9338. Who am I speaking with?
Mary Taylor.
All right, somehow people have got the idea that telephone is enough and it really isn't, but we just do the best we can. All right, Ms. Taylor, stay with me for a minute. Mr. Minsky, can you hear me? He's on mute. Mr.
Yes, Your
Minsky,
Honor.
can you
Yes,
hear
Your
me?
Honor. Yep. Yes, Your Honor.
We called your case at 9:10. You weren't here. I called the hall. You weren't there. Attorney Weiss was here. He advises that they don't believe you're living there anymore, but there are other people in the property. Is that true?
Yes, Your Honor.
Where are you living?
At my other house,
All right, who's left in the property?
Desiree Wing, my child's mother. We had some issues with certificate of occupancy and them not wanting to supply like appliances and everything. And they had made
Well,
a deal with her, so
Chair up until July,
$18,000 in unpaid rent
turned into
are 95. Excuse me, 55, $25 statutory attorney fee.
Your Honor, if I could explain a little bit.
Yes.
Okay. In the incident that happened in January, like I said, was no fault of my own. After Mr. White had received a letter in the mail, okay, then it turned into, I honestly feel that this is in retaliation of the letter that he did receive, okay? Ever since then, he makes comments to me, all sorts of stuff.
Well, just a minute, Have you not paid any rent in more than a year?
I wasn't able to work because of the incident that had happened in January.
All right, well, so nonetheless, you haven't paid it. You owe $18,000 in unpaid rent. 18,300 and $11.20.
Okay, like I said, I wasn't able to work. I was in a
I
wheelchair
understand.
up until
So the fact
June,
that you're not
June or
able to
July.
pay the rent isn't a defense that you haven't paid the rent. And this is a lot of rent for what looks like a little converted garage. But nonetheless, you can't just stay there indefinitely without paying any rent. So the law requires that I adjourn this 1 week.
I mean, I get what you're saying, but like I said, I had no way of any income. When I did call places to try and help me with the rent, they only go up to $750, not $1,000. Okay,
Yes.
I have over $12,000 in medical expenses alone from the incident that had happened in January. Like I said, which was no fault of my own. I was in a wheelchair up until July, and then I ended up having to use a walker. And I mean, my whole life has been turned upside down by this incident in January. I've lost my job of 2 years. I've lost my vehicle. There's not too much more that anybody can actually take from me. In December, Mr. White, he has turned off my heat. I've been sitting here. I've gone through all the cold spells that we have had with space heaters.
All right, well, let's talk about that. The next date is March 7th at 2:10. And I don't want everybody by telephone. If you can't connect by Zoom, I want you to be here live.
Your Honor, March 7th at which time?
2:10, does that work for you?
Yes. Thanks,
All
Your
right,
Honor.
now, Ms. Taylor,
Yes.
what you're describing is a violation of the lockout law. Your landlord can't turn off your heat. It's against the law. So I don't know if they actually shut off the heat or the propane ran out or what happened.
No, I'm sorry. It's a boiler system. Okay. And December 15th, I had let him know. So, I mean, even if something to me was wrong with the boiler system itself, he's literally had plenty of time to get it fixed. I got sick over that. So then I had to, there's another medical expense that I've had to have.
All right, well, let's talk about this. So have you made any effort to try to find a place to go?
I do now. Yes. Yes. Like I said, you know, the first time that he told me that he wanted me out, I was still in a wheelchair. I mean, there's not too much that I can do when I'm in a wheelchair. You know what I mean? And like I said, regardless of what he feels that I owe him, I've lost so much more than what he feels that I owe him in rent. Literally.
All right.
I'm
literally
disability now.
All right, stop.
You know,
he's got a payment to make. You've lived there for 18 months without paying any rent. It's amazing he went as long as he did without asking to collect the rent. So I understand you're in dire straits, but if you had done this earlier, I guess you could have sought some assistance earlier. They're not going to pay $18,000 of arrearage. And you're right, $1,000 is expensive rent for St. Joe County, but that's what the market is going to. I looked at this place and it's quite small. At any rate, when you say you're working on finding a place to go, tell me about that.
well, I mean, like I said, I mean, I tried reaching out for help.
Well, it
but
needs a
like I
wheelchair
said,
ramp for one.
Nobody was going to help me at $1,000 a month. I had talked to Mr. White and tried to tell him, you know, that, you know, they only go up to $750, and he just didn't care. I mean, I could have got a hold of MDHS, you know, when I got served, but he waited for how long to actually serve me papers. You know what I mean? So, like I
Yes.
said, I
All
didn't
right,
have
well-
any place to go, and now I'm going to move in with my son.
Okay,
There's nothing else I can do. You know, like I said, I'm on disability because of all this, because of the incident that happened in January.
okay.
I went from working 74 hours a week
Oh
to
my God.
nothing. To nothing.
Yes, you're right. It's life altering. All right, well, I'm continuing this to March 7th at 2:10 PM via Zoom or live. I can't see you. I don't know who I'm really talking to. I recognize Mr. Davidson's voice, but
Sounds like
it's
me
not
hitting on women on
ideal
MySpace.
to have plaintiff's counsel appeal by telephone either. But
I
anyway,
apologize, Your Honor.
you're gonna get 10 additional days from that day to move, which would be March 17th. So essentially, you've got until March 17th to move, or you could be subject to being evicted. At this point, they're not asking for any money. They're simply asking you to move. Even though this rent is high, I suspect they have a waiting list of people that he could rent it to. So, all right, let's revisit this next Friday at 2:10. Do you have any questions,
Yeah.
Ms. Taylor?
No, like I said, I'll be out next weekend on the 8th.
All right,
The
well,
8th or
if you
9th.
are
Yeah.
out, then you turn in the keys and give your forwarding address in writing within 4 days. And we don't even need have a hearing. But next weekend will be after the 7th. So, all right. Very good. Thank you.
Okay, no problem. Thank you, sir.
All right.
And thank you, Your Honor. My apology.
All right. All right, now we're getting things stacked up here. We've got lots of
Speaking
people
of
here. I've
stacked.
also got, as I mentioned, 5 landlord-tenant matters.
Come on, Judge.
Kalen Kitchen is here, but that matter isn't set till 11. Estate of Graber and Clark is at 11. Versus Nathan Puro, and I don't see,
And that for plaintiff judge, I don't know about defendant checking in.
they're not here. Then I've got Greenwich versus
Oh, you know mega stories.
Lotta. And that's
Lotta.
Chad Spencer, and he is here. And I've got Megro versus Lawfrey.
Well, what
And,
world?
both parties are here on that. So let me take 1 minute, to take these landlord tenant cases out. I'm having trouble with my Kramer box here. I'm gonna stop the record for a moment. We are still on the live feed.
Okay, he's gonna get something out of his Kramer box, whatever that
That
means.
since the install for the room,
You're willing me very much. I said here,
Sorry.
I've got them. I had yesterday. This is a claim for 13,950.11, give or take. The file number is 24177 GC. Mr. Richard Rooston is here on behalf of the plaintiff, and Jonathan Davis is here. I set this for hearing because I had some vague understanding of what was going on. There was a judgment that entered back in August. And judgment was for $13,504. The parties were put in the breakout room and reached some sort of an agreement. Apparently, the defendant has not held up his end of the deal. They filed a motion to set aside the installment payment without really telling me very much information. Defendant has failed to abide by the terms of the order. I don't know how much he paid, when he last paid. So I don't know what he did or didn't do. So Mr. Rooston, what's the status here today?
Thank you, Judge. For the record, Richard Bruson. Judge, I can tell you that since the installment payment order, defendant unfortunately has only made one payment in compliance with the order. That was in October of 2024. And there has been no other payments paid on that order. That payment was in October 2024, $100. And so because defendant is two things, not in compliance with the order. Number two, not appearing on the record today, despite notice to
No,
do
he's
so.
here. He's
Oh,
here.
he's here. Well,
Oh,
Yeah,
all right.
asshole.
If you had told me that in the motion, that he only
Yeah.
made one payment, I probably would have granted it. But what happens is, then I grant the motion, then
Suck
the
it.
defendant asks for a installment payment order, and we chase our tails around. Mr. Davis, you're not gonna like a garnishment very much at all. If I set this order aside, they're gonna be able to garnish your wages and take a substantial amount of your weekly check. They don't care about your rent or your car payment or your insurance bills, comes right off the top. So this
The
was a
tip.
very generous installment payment order at $100 a month. If, so what's your position?
I lost my job.
Cool story, bro.
Where were you working?
Fawn River Cultivation. I used to sell weed.
A lot of those places have gone out of business.
Oh, they're still there.
He's in.
When was that?
I got fired on January 13th.
Well, yeah, the agreement was in August and you only made one payment in October. So you weren't even making any payments when you were working. Are you still on Greenfield Court?
Yep.
Have you found a new job?
No. There's nothing around here
That
that
might
pays
be
a lot.
asking too much.
Well, there is that. All right, I'm just gonna grant your motion to set aside the installment payments. Right now, he doesn't have anything to garnish.
right. Yep. Thank you,
But,
Judge.
so what I suggest, Mr. Davis,
What, do people all of a sudden stop buying weed? Good Lord.
if you do get a job, you file a motion for installment payments.
Garnish the garnish.
The motion is granted, the writ of periodic garnishment may issue. But right now, you don't have a job, so don't have anything to garnish. It could garnish your tax refund. But if and when you get a new job, I would suggest that you contact the Rusin Law Firm and see if you can set up some sort of payment plan. Losing your job is certainly why, but you didn't make any payment anyway. You didn't make any payments before you lost your job. But
Made one
now it's
payment.
even harder since. All right. I grant the order to set aside the garnish, the installment payment. But you're not working. So when you do get a job, I would suggest you call the law firm to see if you can work out some sort of payment agreement and get back on top of this, because this debt isn't going to go away. The judgment's good for 10 years and it could be renewed for another 10.
I need about 350.
All right. Do you have any questions, Mr. Davis?
Can I get a number so I can properly call you people?
Let's take a look.
Well, what do you
Yeah,
want to
you're
call
right.
them?
Let's see here. The motion doesn't have their phone number on it. It
Oh,
has the law
Jesus.
firm. Mr. Rusin, what's your number?
Our landline that Mr. Davis can call any Monday through Friday between the hours of 8:30 a.m. and 7 p.m. is area code 586-868-2737.
Well, I should call
Okay.
them.
What's your guys' website?
www.rvolaw.com.
Okay. Does it have all your information on there too?
No.
Yes, it should, sir.
No, it doesn't have his
Okay, thank you.
information. It's a
Well,
they
very
keep it like a
good.
riddle.
All right, Mr. Davis, good luck to you.
Thank you.
No, they like to confuse people who go to the website. Geez. David, did weed places in Michigan close down? And if so, why?
Oops. Let me remove him.
He's too stoned to remove himself, clearly.
All right, Mr. Rusin, while we got you, let's take your next matter.
Oh, this guy's a winner.
LVNV funding versus Nathan Pirro. No one appears to be here on behalf of Nathan Pirro. I got Bradley's iPhone. Who is that?
I'm guessing Bradley.
I'm here
Bradley
with the
Bruce.
Law 3 crit case.
All right, we'll be with you in a minute. This is a big fat file.
Mm.
It's 24931 GC LV funding versus Pirro. Richard Rusin is here. This was a claim for $11,725.90. Judgment actually entered November 25th by summary disposition in the amount of $12,017.53. Let me give you a name, Mr. Rusin, rather than iPhone, so I keep it straight. The judgment entered, as I mentioned, by summary disposition. So collection efforts start, and the defendant files an objection to garnishment. There's no physical evidence provided of a signature without satisfaction of LVNV funding. Well, that ship already sailed. I already entered a judgment on behalf of the plaintiff by summary disposition. So he's relitigating what I already made a decision on at summary disposition. Plus, he didn't show up. So this is real easy. No basis to set aside the garnishment. And defendant fails to appear for his own motion. So at the time this was done, no garnishment had been filed. But since when he first filed it, I hadn't seen the garnishment yet. The objections are invalid. The garnishee shall continue withholding payment of funds as previously ordered by the court. All right, so motion objection to garnishment is denied.
Thank you, Judge.
Mr. Rusin, are they actually garnishing anything? And this was a
No,
tax.
Judge, your review of the register actions is correct. Judgment was entered, then this objection to garnishment was filed. I don't want to put words in the mouth of the defendant, but again, if defendant's not here to prosecute its own objection, you are correct and right in denying the pleading that's on your docket today.
All right, well, we brought you over 2 minor matters, but we did take care of both of them, so.
Well, that's always good to see you, Judge.
All right, I'll see you next time. Thank you.
All right, thank you.
All right, we're plugging away here to see if we can finish these by half an hour. Next. Is Lori Greenwich versus Tim Latta and Samantha Latta. The file number is 241229GC. Mr. Chad Spencer is here on behalf of the plaintiffs. The defendants are not, oh, and Mr. Buckland is here on the other side.
Yes.
This is a motion for summary disposition, and I already can predict what Mr. Buckland's going to say. There is a material issue of fact, but this might qualify as my least favorite type of case, where one family member is suing another family member, and that probably shouldn't even be in here in the first place, but nonetheless, here we are. So, Mr. Spencer, this matter is well pled. Normally, when I have a summary disposition motion, I have an unrepresented defendant that doesn't understand what it's all about. But Mr. Spencer, this is your motion, so let's hear from you first.
Oh.
It's actually Attorney Buckland's motion, Your Honor.
Oh, I got it upside down. Plaintiff's response to defendant's motion for summary disposition. Yes, told you I had all these down. Mr. Spencer's reaction is going to be there is a material issue of fact. So this summary disposition by defendant, and part of the issue is here, there's 2 different Cadillacs. One's pink and one's coffee colored, I think. One's Chuck Berry and one's Aretha Franklin.
What?
But anyway, Mr. Buckland, what would you like me to know?
Well, I guess just to begin with, Judge, you're right. It's an unfortunate situation anytime we've got family suing family. And I did reach out to Attorney Spencer this week, and we've tried to have some discussion just to lead with that about trying to resolve this, but we haven't got it resolved yet. So with regard to my motion, our argument is, number one, we don't believe that there is a valid contract here to enforce. And so any lawsuit for breach of contract, I think is inadequate. Number one, as the court knows, common elements of a contract are offer, acceptance, consideration, mutuality of obligation. And the problem we have here is I believe that the facts are undisputed, that there was a check for $19,000 that came from a joint account, but that check was canceled. And that was intended for the purchase of a 2018 Cadillac. And then in Ms. Greenwich's affidavit, she indicates that there was another check for $20,664 that was also canceled. And so that kind of brings us to the cause célèbre, which is the $16,900 that Samantha Latta withdrew from the joint account. And so we only get to that point from my client's perspective because there was some text messages and things exchanged where there was some preliminary agreement that Tim Latta was going to basically borrow funds from his mom, and it was something along the lines of $500 per month on 2% interest. But the reason that the first 2 checks were canceled is because the Lattas backed out of it and said, look, this is too much money. We don't need to be.
Define canceled.
So basically, I believe that the cashier's checks, I think, were actually issued, but then the checks were never cashed and the money was just left in the account essentially.
So these were cashier's checks from the defendant to the plaintiff that the plaintiff never cashed?
I can't recall. It was either the defendant either took them out or the plaintiff took them out, and then one of them or the other canceled them. So the money never came out.
All right, so okay, go ahead.
And those are attached as exhibits to the plaintiff's affidavit to the motion.
Yes.
And so basically, I think that supports my client's argument that, look, we changed our mind. We can't afford this. We're not going to take a car loan from you. And then it was only upon the insistence and urging of Lori Greenwich that look, I've got some money. I've got this inheritance from my mother. I want you to have this. Go ahead and withdraw the money. And so since there was no promise of repaying it, that's what they did. And they pulled the $16,900 out to purchase a 2011 Cadillac CTS. So there is nothing in writing that establishes that there was ever any agreement to repay any money for the 2011 Cadillac CTS. Any agreements that were floated through text messages or otherwise were for different vehicles that never came to fruition. There's reference in the affidavit of Miss Greenidge that there were 8 payments made. My clients disagree. I mean, many of those things were stated that they were cash payments, and that those cash payments just were simply never made. If there was ever any payments made from the Lattice to Miss Greenidge, it was for something completely different than this 2011 Cadillac CTS. But they just flat out deny that many of the payments that they listed in the affidavit ever happened. In addition to that, there was an affidavit by Amanda Darr, which is the sister of Tim Latta. And I guess I just point out, my client denies, when I asked him and went through the response brief with him, he denies that conversation with his sister ever took place.
Of course he does.
And when I read that statement by Amanda Darr, that he showed up in sometime in April and made a statement to her that he wanted to take her for a ride, and that basically his mom was loaning money and it was because it was a certain interest rate. It just seems oddly specific. And I just think we're dealing with a family dynamic here, Judge, where people are taking sides and they're not getting along, and it's unfortunate.
Well, even in your argument, you just pointed out several points of contention indicating issues of material fact. Even in the arguments that you've made, there are a bunch of factual disputes. Mr. Spencer, what's your response?
Your Honor, my response would be that, or my client's response would be that we do believe there definitely are issues of material fact, Your Honor. We do believe that there was a formation of a contract in this case. The parties, we have parties that were competent to contract.
An oral contract?
An oral contract, not nothing in writing, Your Honor.
Of course
An
not.
oral contract. We had parties competent to, contract to the oral contract. We have proper subject matter, being a Cadillac. It's not, as I mentioned in my brief, it's not, for an invalid purpose or being against public policy. There was consideration given in that Ms. Greenidge, was willing to loan the $16,900 to the Lattas, and the Lattas agreed to repay that amount. And they did, Ms. Greenidge will testify, Your Honor, that they did make 8 payments to her. 7 of those were via cash and 1 was via a check. And they did also, there was a mutuality of agreement. She agreed to loan them the money and they agreed to take the loan from her. And then there was mutuality of obligation, Your Honor. She was, based on that oral contract, she was obligated and she did loan them the money, and they were then obligated to repay her. And I think it's telling that the testimony that she will give is that, 8 payments were made. And also there was a text message from Mr. Latta in June of 2023, which I have in Ms. Greenidge's affidavit, indicating that he knew it was a loan, Your Honor. I believe between that and also Amanda Darr's affidavit testimony, I think there's definitely some issues of material fact. And I believe this case would need to proceed to trial based on that.
Mr. Buckland, it's your motion. Any final word?
Final word, judges. Also, we've got statute of frauds argument that we've made, basically indicating that the representation is that the repayment terms were $500, 2% interest. The total purchase price was $16,900. we argue that that's not something that would be repaid within 1 year because of the repayment terms, if that were in fact what the agreement is. And then the last argument is related to it's undisputed that these funds came from a joint account, Judge. And so the statute cited as MCL 487.703. And I believe that starts kind of with a presumption that basically if you're joint owners on the account, any one of the joint owners or the survivor has a right to those funds. And then it's up to Ms. Grindage essentially to overcome that presumption by clear and convincing evidence, and in basically having to prove what the intent of the account creator was and what the realities of ownership are. And there's some cases that talk about that, but it's undisputed.
Well, let me stop you for a minute. That's a very compelling argument. They're on the account. They took the money out because their name's on the account. Sorry. But even there are some factual issues you just raised about creators of the account. So that's sort of well, there's a couple issues. There's first of all, they say we never even had such an agreement. B, there's the statute of frauds issue. This contract is not in writing and it wouldn't be resolved within 1 year. And C, they're saying we used our own money out of a joint account to purchase this, which could be a winning argument. But there are factual disputes. And as much as I'd like to get rid of this, I mean, as much as I'd like to resolve this or take it off my docket, I think there are things that are going to need to be resolved under oath. But that argument has merit if they can establish the things you were starting to discuss. So I'm tempted, but the motion for summary disposition is denied.
Thank you, Judge.
Does the court need me to prepare an order, Judge?
Yes, please. I'm going to set this for trial. Can we do this in a half a day or will we need a whole day?
Wow.
I'm usually pretty to the point. So, I mean, from my perspective, I think I can get through my witnesses fairly quickly.
I think we could probably do it in half a day, Your Honor.
All right. And in the meantime, I know you're going to continue to discuss the matter. So I don't have time to do it right now. Consult my calendar. I'll have my staff contact you and we'll clear a date that works for both of your calendars.
And we'll do our best to try to resolve it for you, Judge.
Yes, we will,
Does
Your Honor.
everybody have all the discovery they needed?
If anything, if it's going to go to trial, I may ask for some additional discovery either from the bank or from regarding some of the text messages that are referenced.
Well, I'm going to set this.
I would say the same, Your Honor.
All right, I can certainly find a half a day someplace. I'll try to set it within the next 60 days, but motion for summary disposition is denied. And Mr. Spencer will do the order.
So I don't think it's happened yet.
Certainly, Your Honor. And will the trial be, will that be in person, Judge?
Yes, the trial would be live.
Okay.
All right. Anything further?
Just how often or how long would you allow us additional discovery, Your Honor? Another 30 days or?
Well, I said the trial would be at least 60 days out, so you have 30 additional days for discovery.
Okay, thank you.
Maybe the snow will be melted by then. All right, and we can have a half a day trial. Sometimes I'll block out a whole day, and this has happened several times in 2024. I have the whole day blocked out. It's not going to settle. It's not going to settle. The day before it settles, I have with a blank day on my calendar. But you guys are very cordial with one another. You're trying to get to the heart of this. It's a family matter. This is certainly costing each of the parties money and attorney fees. All the reason this should be resolved. But if it can't be, we will have a trial. But I'll block out a half a day, more than 60 days out. If you need any issues, you can always ask for a hearing on it if there's a lack of cooperation and discovery or something like that. Otherwise, I won't just blindly set the date. We'll contact your offices and make sure the date works for both of you.
Okay.
All right, thank you.
Okay.
Thank you, Judge.
Is
All right. We'll have to keep an eye out for that. I'm going to end now. Hella starts 10 minutes. Let me grab her link. Forgot to do that. She is covering Brian Koberger and the Cy Ray. Very interesting testimony that happened a little while ago, kind of going back over it and what it might mean for the trial. So I am going to end tomorrow. Hopefully Judge Fleischer should be back tomorrow. He wasn't here today. Got a DM from the other guy who runs Judge Fleischer. He said that he wasn't going today, and he was quite right. So hopefully we'll be back tomorrow. Maybe there'll be a trial, and we can watch that. That'll be at 10 a.m. for Judge Fleischer. And yeah, so I shall see you guys later. Bye.